All right, let's talk about the court organization. So we are going to start at the bottom, and let me show you a chart. We're starting at the bottom. So we are going to first talk about local level courts. And again, because we have a decentralized court system in Texas, when we talk about our judicial branch, we have to talk about different levels, not just state level. All right, let's talk about municipal courts. Municipal is another word for local city courts. And so let's talk about what jurisdiction, what kind of cases can a city court hear? Well, they can hear low-level minor violations is what they say. Low-level violations. And I'm just going to tell you now that that's a Class C misdemeanor. Just have to take my word for it till we get to chapter 10. And that happened within their city limits. So you cannot get a ticket in Grand Prairie from an Arlington police officer, because they only have the ability to give a ticket within the city that they are employed, and they can only send cases to their own city courts. They also hear violations of city ordinances. Like I got a ticket one time after a tornado because I had a swimming pool in my backyard and the fence was blown down, and you were supposed to repair a fence within 24 hours of it going down if you have a swimming pool. And so I got a ticket for not repairing the fence after the tornado. City of Arlington, man. They in municipal courts, the judges get their jobs by being hired by the city council. And so they are the only level of court that does, or the only courts that don't actually have elected judges. And a lot of times these courts don't keep a record. They don't have a court reporter sitting there typing. They often don't even have a tape recorder going if you have a trial. So to be a court, what is called a court of record. So you have the ability to, and permission from the state of Texas, to have a court reporter or to record proceedings. And if you have not done that, if you don't have that permission, then if somebody appeals a case, listen to me, if somebody appeals a case from a municipal court that is not a court of record, doesn't have a record of the trial or the hearing, that case, number one, goes to a county court. Just put that in your back pocket. It goes to a county court. And number two will be, here we go with the Latin, a trial de novo. That means of new, brand new. They will start the case over as if it never was heard in municipal court. And it is a lot of times these cases take forever to get heard. You review, and this, when I was doing criminal law for that short period of time, we always appealed cases if the court was not a court of record. And a lot of times the cases would get dismissed because the police officer wasn't there anymore. The police officer didn't have time to show up in county court, all kinds of stuff. So that was our trick. You always appeal a ticket from municipal court. So on the same level as a municipal court, the lower level local courts is called a justice of the peace court, and we actually call them JP courts often in Texas. Any county, any given county can have up to 8 different precincts, and justices of the peace are elected. They are elected. Now, are there qualifications to be a justice of the peace? No, there are none. Zero. There are no education requirements. There's no citizenship requirements. Well, no, there's no nothing. And in Tarrant County, justice of the peace make like $150,000 a year, 170, quite a bit. You do have to run. You do run in partisan elections, so it kind of depends on your county and whether or not they have a tendency to elect Democrats or Republicans. We in Tarrant County have 2 justices of the peace that are Democrats. One of them is in Precinct 8, which is kind of the Stop 6 Highland Hills area. And one is in Precinct 1 that includes north side of Fort Worth, not Dallas. So what kind of cases can a justice of the peace court hear? Well, they can hear criminal cases where the fine is less than $500, minor violations, if it did not happen within a city limits. So anything on the outskirts of town, on county land, where like a sheriff gives you the ticket, that is going to go to a justice of the peace. They also can hear civil cases, and they can hear civil cases where the amount in dispute is less than $10,000. We sometimes call these small claims courts. They are designed to give a easy and cheap way to resolve disputes that are not hundreds of thousands or millions of dollars. So, if you have ever watched like People's Court, sometimes Judge Judy, they actually are real cases, but that's what you can expect. People talking all out of turn, people saying stuff that they're not supposed to. Justices of the peace do not care. A justice of the peace court can also issue warrants, search warrants, and arrest warrants. And once you get the job, since there are no qualifications, once you get the job, they do require you to take some training, but it is it's one of the best jobs going. Justices of the peace can also collect money for marrying people, for actually officiating weddings. And if it is a small county that doesn't have a coroner, the justice of the peace will act as the coroner, basically declare that someone has passed away and sign death certificates. So justices of the peace, depending on if it's a large county or a small county, have a lot of jobs and wear a lot of hats. But they have their courts where they hear small claims and Class C misdemeanors or criminal cases where the fine is less than $500. So we have talked about local trials of limited jurisdiction. Notice that on the side where it says limited jurisdiction. Limit of municipal courts, fine of $500, and city ordinances, because sometimes they have fines. Limit on justice courts, civil cases up to $10,000, and Class C misdemeanors. So now we are going to talk about county level courts. County level courts. So there are really two types of county courts in Texas. One of them is called county court. Just county court. That's the easiest way to say it. We have 254 counties in the state. Every county has one county judge. They are elected in partisan elections, meaning you have to run as a Democrat or a Republican or a Green Party or Libertarian, and they serve 4-year terms. What is their jurisdiction? County courts can hear civil matters where the dispute is between $200 and $10,000. So there's some overlap between county courts and justice of the peace courts. And they can also hear probate matters. Probate refers to a case where the person that is the subject matter cannot speak for themselves, either legally or physically is unable to speak for themselves. So the court's job is to take care of the affairs, or sometimes we call it the estate of the person. And why would they not be able to? Well, they could be too young. You cannot represent yourself or have a case pending in court if you are under 18. So they're going to have to appoint someone to represent you. If you are mentally incapacitated, if you have passed away, you're not going to be able to physically represent yourself. So they're going to appoint someone to handle your estate. If you are have been in an accident and you are not able to leave the hospital, or you're not conscious, or if you are elderly and you have been diagnosed with Alzheimer's or dementia, so you're no longer able to take care of your affairs. So those are all examples of probate matters, and those are heard in county courts. Now, on the criminal side, county courts hear Class A misdemeanors. So, it is criminal matters for serious misdemeanors, Class A and B, I think, where punishment is greater than $500 or jail time is less than 1 year. So that's a Class B misdemeanor. So the lowest is C, middle is B, highest is A. So they can hear Class B misdemeanors in county court. Now, let's think about this. Harris County has, 5 million people? Dallas County has, more than 1 million, because there's 1 million people in Dallas. Tarrant County has, we're about to get new census numbers, but at the last census, just under 800,000 people in the city of Fort Worth. That is not including the surrounding counties. So it became quite apparent that you were not going to be able to have just one court handling all the Class A and B misdemeanors and all the probate matters in some counties. So, what the court did was decided that they were going to create some courts through the law. And those are actually called county courts at law. County courts at law can hear up to $200,000 in civil matters, and the same for criminal matters, class A and B misdemeanors. They also can hear appeals from municipal courts. Those de novo appeals, they can hear those as well. So you have Tarrant County, Dallas County, Harris County, Bexar County, Travis County, I know for sure, all have separate probate courts. So all they hear is probate matters. Then they have civil courts, county civil court at law number 1 through 8. And then they have criminal courts, county court at law number 1, 2, 3, 4, 5, 6, 7, 8. So that is a lot of county level courts. If we are looking at numbers, municipal courts hear a lot more criminal cases than civil cases, 91%. Justices of the peace hear about 81% of criminal cases. County courts hear it's 61 to 39%. We're now going to talk about district courts. Now, district courts hear a lot more civil matters. Courts of appeals is about half and half, and then we got the Court of Criminal Appeals and the Supreme Court, which we'll talk about momentarily. Let's talk about district courts. So district court is a court. Let's go back and look at our chart. This is a court of unlimited jurisdiction. It's a trial court of general and special jurisdiction. So as far as criminal matters are concerned, district courts can hear felonies. As far as civil matters are concerned, district courts can hear anything above $200 with no top limit. So unlimited jurisdiction as far as civil matters are concerned. And they also hear, district courts also hear family matters. Family court includes divorces, child support, child custody, name change, if someone is going to be removed, parental rights are going to be removed, like CPS, Family and Protective Services cases. Those are going to be heard by district courts. And in Texas, juvenile cases are considered civil, and they are heard in district courts. So unlimited civil jurisdiction, bottom is $200. Felony cases is criminal, and juvenile cases, which are this hybrid civil and criminal, but are heard in family court, and they hear family matters. District courts don't have a lot of trials. In fact, a lot of criminal matters end up in a plea bargain, meaning that the district attorney or the prosecutor offers some type of deal that would give you a lower sentence or keep you from getting the death penalty and not having to go through a trial, and you agree to plead guilty in exchange for not having to go through the trial, and you just go ahead and take the fine or the time that they are offering. That's called a plea bargain. It's a negotiation between the prosecution and the defense or defendant in the case. All right. So in Texas, we have 3 levels of court that are have appellate jurisdiction. Well, county courts have appellate jurisdiction, for municipal court, for municipal matters. But so we have a court of appeals. There are 14 courts of appeals in the state of Texas. All of them have several judges, and all of those judges are elected in partisan elections. They hear appeals from county court and district court. And I suppose they can hear appeals from JP court as well. They hear both civil matters and criminal matters. They do not have to accept appeals. Everybody that appeals and says that the judge did something wrong does not get their case heard. And a lot of people cannot afford to appeal a case in the first place. So they don't hear anywhere near as many cases as district courts and county courts do. And their job, of course, is to review the case to see if there were any legal decisions made that do not comply with the law, or that affected the outcome of the trial or hearing adversely. Then at the top, we have two courts that are called courts of last resort. If the matter is purely state law, it doesn't involve any violation of United States constitutional rights or violation of some law that was some federal law, then this is the end of the road in Texas. So that's why we call them courts of last resort. We have two. And don't ask me why, because I got nothing. I don't know. Us in Oklahoma, there are two states that have this system. We have the Supreme Court. The Supreme Court hears civil matters. And we have the Court of Criminal Appeals, and they hear criminal matters. There are 9 justices on the Supreme Court, or 8 justices and a chief justice, and 8 judges and a chief judge on the Court of Criminal Appeals. So a total of 18 people at our 2 highest courts. The Court of Criminal Appeals has automatic and exclusive jurisdiction to review death penalty cases. Where would a death penalty case come from? It would come from a district court, because district courts are the only ones that can hear felony cases. You can say, I don't want it to be appealed, I want to just accept it. It's still going to go to the Court of Criminal Appeals, and they're going to go through all the proceedings and all of the decisions with a fine-tooth comb to make sure that your rights were not violated. All right, let's talk about that Supreme Court. So they're the final court of appeals on any state matters in civil cases and juvenile cases, which are odd, but okay. They can also issue writs, telling you that you have to do something. And they are in charge of any hearing to remove a judge or involuntary retirement of a judge. So this would be in lieu of an impeachment hearing. They can actually hear cases about judicial misconduct. They also are in charge of licensing for all attorneys in the state. And they get to establish the rules for judges. So they actually have written a code that says this is what judges can do, this is what judges must do, this is what judges can't do. That is all the requirement, that is all part of the power of the Supreme Court. I don't know what FPO stands for. Oh, this. I don't know. So the person that's sitting in the middle is the Chief Justice. There are 9 of them, and a total 1 Chief Justice and 8 associate judges. They run for these offices. They serve for 6 years. There are times when our Supreme Court has a policy making, basically law making function. And the example that they give is the Edgewood versus Kirby case. And basically, in that case that was heard in 1989, right after I got out of high school, I graduated from high school in 1988. But this case was making its way through the court system when I was there. And basically, they said that the way that Texas funds public schools is unconstitutional because there are some school districts that just are not going to raise enough money in property taxes to sustain. And so really the state of Texas needs to find more money or find a way of getting additional funding to those school districts that don't make enough to sustain their school districts in property taxes. The state of Texas did not elect to just give more money or to guarantee a certain level of money. What they decided to do was something we call the Robin Hood plan, and this is still in effect. They actually pair up really well-off school districts with less well-off school districts and require the well-off school districts, South Lake, Mansfield, Grapevine would be some examples. They require them to actually take a percentage of the property taxes that they collect from their citizens in their cities and or in their jurisdiction and send it to the school district that they're paired with. So the state of Texas isn't paying any extra money, but school districts are giving up some of their money. And so that was the way that Texas resolved it. And it has not, there's several times people have come up and said this isn't fair. And the Supreme Court is like, well, maybe you're right. What we were trying to do was get the state of Texas to just send more money. But, they need to fix it. But a court can only make a ruling. They can't physically go and do it. So they can't make the legislature do something new. And the legislature has flatly refused for years to do something different. All right, let's talk about juries. So there are 2 types of juries. There are grand juries and there are petit. I'm sure that's not how you say it, but I went to Baylor in the middle of Waco, so that was how my law professors said it. Petit juries. All right, let's talk about grand juries first. So grand juries are required in the Texas Constitution. There are some states that don't require grand juries. It is in the United States Constitution, but it has never been incorporated. Ooh, if you haven't taken federal government, you have no idea what I'm talking about. Just take my word for it. States are not required to use grand juries, but Texas definitely does. What does a grand jury do? Their job is to determine if there is sufficient evidence to bring somebody that has been accused of a crime to trial. So the most recent grand jury that has been in the news has been the grand jury in Kentucky that did not file charges against police officers that obviously caused harm to a young lady named Breonna Taylor. Walked into her house It was in a no-knock warrant is what we've heard, and just started shooting when they saw her boyfriend with a gun. Or he may have actually shot at him. But and so the grand jury looked at the evidence that was presented to them, and they decided to no bill some of the police officers, meaning that they decided that there was not enough evidence to actually charge them with the crime. That is called an indictment. Indictment. Look at the spelling of it. So, a no bill is a decision not to proceed. A true bill is a decision to proceed. Now, of course, some of the grand jurors are starting to come out and talk, and they're saying that they were not even presented with the evidence to make a decision to charge the other police officers. I mean, for the most part, grand juries do what the person that is presenting the evidence wants them to do. That is true. A lot of times, if a police officer is charged with a crime, they'll take it to a grand jury, and the grand jury, more often than not, will decide not to charge a person. Like if somebody shoots someone in their home, it's clearly self-defense. They clearly have an excuse for using force. Then they'll take it to the grand jury. The grand jury will say there's just not enough evidence. This person had an excuse for what they did, and they will no bill them. If they decide that there is enough evidence to charge someone with the crime, they issue a true bill. Then the case will proceed with an indictment. A district attorney does not have to take a case to a grand jury. A district attorney can decide to charge someone on his or her own, and district attorneys are elected officials. So they can look at it and they can say, I believe that there's enough evidence, here's what it is, and charge without taking a case to a grand jury. This often happens on minor offenses, but I have also seen it when there is really no dispute in the district attorney's mind about the amount of evidence, and it's not controversial. So, two choices: you can take it to a grand jury. These people that are that sit for months and months and hear hundreds of cases and decide, yes, we're going to indict, or no, we're not going to indict. Or the district attorney can just say, we're going to indict and issue an information. All right, let's talk about petit juries. So these are juries that show up when someone has requested a trial by jury. Citizens. This is one of the privileges and requirements of being a citizen of the United States. That is serving on a jury. You can have juries in civil trials. You can have juries in criminal trials. If the case is in county court, the number of jurors is going to be 6. If the case is in district court, then the number of jurors will be 12. So attorneys have to decide and pick juries. And so the attorneys get to decide who is going to serve on their juries. And they do this through a process of strikes. So they usually, if it is a district court case, then they're going to get a pool of about 36 people. If it is a county court case, then they'll have a pool of about 18 people. They'll bring them all in, they'll give them numbers, and they will proceed to ask questions. So they usually will have a questionnaire. On the questionnaire, it'll ask, Are you familiar with this case, or do you know the attorneys? Do you know the judge? Have you ever experienced X, Y, and Z that had some? Do you feel that you might? Is there any reason why you might not be impartial? And then where do you live? How old are you? You know, the demographic stuff. So if somebody puts down, I know the prosecutor, he prosecuted me 15 years ago and I can't stand him, then that person probably is not gonna be is not qualified to be a juror. So that person would be challenged for cause. If a person says, well, you know, I'm purple and he's blue and I can't stand blue people, I just assume that if somebody is blue, then they committed the crime. So I have a prejudice, then that person can be dismissed and would not qualify to be a juror. So you basically call that a challenge for cause. You go through the questionnaires, you're like, Judge, this person says that he knows me. This person says that he has a bias. This person says that she can't stand blue people. And the judge will say, you know, thank you for your service. Here's your, $7, whatever they are paying now for jury service, $12 a day. And you get to go on home. Then the attorneys get to decide literally who will be serving on the jury. Which of these people that we now know are qualified would be best for my client or for my cause. We call that a peremptory challenge. So you can every time that I started talking, she wrinkled her nose up, and I just don't think that she likes my client. And so you just strike them. So that is called a peremptory challenge. You really don't have to have a reason. And they stand, basically they pick the first 6 people in county court or first 12 people in district court that haven't been stricken by one of the sides. In criminal matters, not only is there a requirement that you prove a case beyond a reasonable doubt, there's also a requirement that the jury agree to the verdict unanimously. Civil trials, you just have to have majority. But in a district trial, it has to be, everybody on the court has to agree to convict. If one person says, I just cannot agree, and the jury is not able to convince that one person, or if multiple people say, well, I want to convict, and another group says, I don't want to convict, we call that a hung jury. And since verdicts have to be unanimous, if they get to the point where they just are not able to agree, then we call that a hung jury. And what that means is that you didn't get a final verdict in the trial. They will dismiss the case. And since you didn't get a final verdict, the prosecutor can decide to try you again. Sometimes they will, sometimes they won't. But if it results in a hung jury where you didn't get a conviction because they could not agree, then the prosecutor can file the case again. Not double jeopardy because you didn't have a final verdict. All right, let's talk about selection of judges. Remember, in Texas, we elect all of our judges. They run in partisan elections. A lot of times we don't know anything about them except that they are a Democrat or a Republican. And that's how we make our decisions for judges. Some other states do it differently. For instance, there is something called the Missouri Plan. Missouri Plan is kind of this hybrid. Like the President of the United States, nominates all the federal judges. They get approved by the Senate. They don't have to run, and they serve for life. The Missouri plan is kind of a hybrid, and there's some states that do appointments as well. Missouri plan says that the governor nominates or appoints people to the bench. So they serve for a period of time, and then there is an election to see if that person can stay. So if somebody is doing a bad job, there's a way to get them off. It's not like they're appointed for life, but the initial position is granted by the governor. So this obviously is what they do in Missouri, and there are lots of states that have adopted that. I had a student one time that told me that in Arkansas they have nonpartisan elections. So they do elect their judges, but they don't put on there if they're a Democrat or a Republican. So you have to go and check to see what have they done before, how do they feel about issues. You have to do a little bit more research, or have some name recognition before you elect judges. You don't have that Democrat or Republican indicator to help you out. This chart indicates that a handful of states have partisan elections. There's Arkansas, Mississippi, and Georgia, and several states in the West, far West, have nonpartisan, and all those are on the East Coast except Hawaii has appointments. So it does vary. The ones in blue use the Missouri plan, that hybrid appointment elections to stay in office system. So it varies as much as methods of voting and methods of counting votes varies from state to state. So again, it is difficult to figure out who is the person that should get your vote. We often, especially like in Tarrant County, where we have district court judges, criminal district court judges, civil district court judges, county court at law judges, criminal county court at law judges, civil county court at law judges, justices of the peace that we all have to elect, plus the Court of Appeals and the Supreme Court and the Court of Criminal Appeals. We don't know how these people are. We don't know how they run things. We are usually there's no way to catalog all that different information about what these people do. So we usually use indicators that they are Democrat, they are Republican. We have a tendency to vote for Democrats, or we have a tendency to vote for Republicans. Those people usually get those jobs. Now think about that. You're running for office and you are a judge. One thing that is required when you are running for any office is that you're going to have to get campaign contributions. Yeah, you think that could be a conflict of interest, that people are paying money to get you elected? We already know that when people pay money, they expect something in return. People don't just donate money out of the goodness of their heart. And we have found over and over again that we have seen large campaign contributions from companies and people that have cases that are going to be coming up through the court. It is a huge potential for conflict of interest. And that is probably one of the biggest problems with having partisan elections. If we are looking at the ethnic and gender diversity in our court systems, there's not a lot. Just like the legislature, we have a lot more white males But women are in the majority in our appeals courts, running for appellate courts. Our lower courts, our district courts, county courts, and JP courts are dominated by males. Let's look at a chart. So if we look at the Texas population, and this is based on the 2010 census, and actually this is based on 2017 estimated numbers. So Asian Americans are 5% of the Texas population. They are 1% of judges. African Americans are 13% of the Texas population. They are 5% of judges. Latinos are 39% of the Texas population. They are 17% of judges. So each of those groups is underrepresented in the court system. Overrepresented are Anglos. They are 42% of the population, but 76% of the bench, judges. Females are 50% of the population, 35% of judges. Males are 50% of the population, but 65% of judges. So there, of the minority groups, Hispanics have the largest percentage, which totally makes sense because they have such a large percentage in the population. But they are still underrepresented in Texas politics.